Originals will be violated.
I please the débat.
Willing debate.
Honourable Member for Edmonton, St. Albert.
Thank you very much, Mr. Speaker. It is indeed an honour for me to participate in the debate on the Senate's message to this House of Commons on Bill C-10, the Safe Streets and Communities Act. As you know, Mr. Speaker, Bill C-10 is a comprehensive crime bill that addresses a number of issues, and if I can briefly outline them: supporting the victims of terrorism, strengthening sentences for child sexual offences, serious drug offences, as well as for violent and serious offences vis-à-vis the use of conditional sentences, enhancing post-sentencing measures to enhance offender accountability and management, strengthening the youth criminal justice system's ability to deal with serious repeat and violent young offenders, and enhancing the ability of the immigration system to protect vulnerable foreign workers against abuse and exploitation, including through the use of human trafficking. Though I will focus my remarks, Mr. Speaker, on the provisions of Bill C-10 that deal with serious drug offences, I want to clearly state to all members of this House my unequivocal support for Bill C-10 in its entirety, and also for the amendments as proposed by our colleagues in the upper chamber of the Senate. Mr. Speaker, this part of the bill has been before us, or before the Senate, on several distinct occasions. I would like to remind you, Mr. Speaker, and all members of this House, that the portion of Bill C-10 which proposes various mandatory minimum sentences falls within the ambit of Canada's national anti-drug strategy. And that strategy proposes a two-track approach, one which will be tough on drug crime and the other which will focus on the victims of drug crime. Mr. Speaker, the national anti-drug strategy includes three action plans. First, preventing illicit drug use. Secondly, treating those with illicit drug dependencies. And finally, combating the production and distribution of illicit drugs. Mr. Speaker, the action plan to combat the production and distribution of illicit drugs contains a number of elements, including ensuring that strong and adequate penalties are in place for serious drug crimes. It is within this context that this bill must be viewed if one is to view it fairly, Mr. Speaker. Moreover, this bill follows through on one of the key elements of the priority of the government to tackle crime, which this government has repeatedly identified as one of its key commitments. Mr. Speaker, I can tell you that there is wide and vast support for this bill from a great number of ordinary Canadians, Canadians who are concerned about drug abuse, Canadians who are concerned that marijuana grow operations and methamphetamine production and trafficking have gotten out of control, and Canadians who are very concerned that these activities pose a serious threat to their own safety and the safety of the communities in which those individuals live. This legislation, Mr. Speaker, as you know, also has the wide support of police officer organizations in Canada, including the Canadian Chiefs of Police, the Canadian Police Association, and the Board of Canadian Police Associations. But, Mr. Speaker, we have responsibility as legislators to make sure that our criminal law stays on top of serious developments in our society. And, Mr. Speaker, over the last decade, domestic operations related to the production and distribution of marijuana and synthetic drugs has dramatically increased, resulting in very serious problems in several regions of Canada. And as you know, Mr. Speaker, I live and represent Edmonton, and Edmonton is certainly one of the regions in Canada that have seen an epidemic growth in organized crime and the violence that's associated with it. In fact, anecdotally, last year there were 44 homicides in Canada, and sadly, Edmonton led Canada in that statistic. In some cases, Mr. Speaker, these problems have overwhelmed the capacity of law enforcement agencies to be able to deal with these phenomena. These illegal operations pose serious health and public safety hazards to those in or around the grow operations. They produce environmental hazards, pose cleanup problems, and endanger the lives and health of the communities at large. Moreover, Mr. Speaker, organized crime groups and criminal gangs are resorting to increased violence to establish their dominance over the drug trade in various metropolitan regions of the country. Sadly, but unavoidably, innocent persons are being hurt. This is not to say that all drug offenders are necessarily dangerous or that all forms of drug trades are violent. And Mr. Speaker, Bill C-10 recognizes this, and that is why it is being proposed in this bill. What is being proposed in this bill is a focused and targeted approach, a surgical approach, if you will. As has been stated before, the new penalties will not apply to possession offenses, nor will they apply to offenses involving certain types of drugs. What this bill does is focus on the more serious drug offenses involving the most serious drugs. Overall, Mr. Speaker, the proposals represent a tailored approach to mandatory minimum penalties for serious drug offenses. And Mr. Speaker, I would like to remind all members of the House how this part of the proposed Bill C-10 would operate. It's a little technical, but bear with me if you will, Mr. Speaker. For Schedule I drugs, that is for drugs like heroin, cocaine, or methamphetamine, the bill proposes a 1-year minimum for the majority of the serious drug offenses in the presence of certain aggravating factors. Some of those aggravating factors, Mr. Speaker, are as follows: that the offense is committed for the benefit of, at the direction of, or in association with organized crime, or the offense involved violence or the threat of violence, or weapons or the threat of the use of weapons, or the offense is committed by someone who is convicted in the previous 10 years of a designated drug offense. And I think we'll all agree that in the presence of those aggravating factors, a minimum mandatory sentence ought to apply. Moreover, Mr. Speaker, if youth are present or if the offense occurs in a prison, the minimum is increased to 2 years. In the case of importing, exporting, and possession for the purposes of exporting, the minimum penalty will be 1 year, again, if certain aggravating factors, such as the offense was committed for the purposes of trafficking, and for 2 years if the offense involves more than 1 kilogram of a Schedule I drug. A minimum of 2 years is provided for a production of an offense involving a Schedule I drug. The minimum sentence for the production of a Schedule I drug increases to 3 years where aggravating factors relating to health and safety are present. And these factors, Mr. Speaker, are the following: the person used real property that belonged to a third party to commit the offense. The production constituted a potential security, health, or safety hazard to children who were in the location where the offense was committed or in the immediate area, or the production constituted a potential public safety hazard in a residential area, or the person placed or set a trap. We hear all too often of rental properties that are turned into grow operations with significant damage having been done to the real property of the landlords. And it's that type of aggravating factor with respect to damage to real property belonging to a third person that this portion of C-10 captures, and I would suggest to members of this House appropriately so. For Schedule II drugs, that is, drugs such as marijuana, cannabis resin, and others, the proposed mandatory minimum penalty for trafficking and possession for the purposes of trafficking is 1 year, again where certain aggravating factors such as violence, recidivism, or organized crime are present. The minimum penalty is increased to 2 years, Mr. Speaker, if other aggravating factors such as trafficking to youth are involved. In the case of importing, exporting, or possession for the purpose of exporting, Mr. Speaker, the minimum penalty is 1 year imprisonment, again, when certain aggravating factors are present, such as the offense was committed for the purpose of trafficking. For the offense of marijuana production, and a lot has been said about this in the media and in the opposition, and some of it is factual, but a lot of it is misconstrued hyperbole, so I think it's important that members know what the bill actually says. The bill proposes mandatory penalties based on the number of plants involved. Production of 6 to 200 plants, and if the plants are cultivated for the purpose of trafficking, the minimum mandatory sentence is 6 months. And if the production is of a quantity of between 201 and 500 plants, the minimum mandatory is 1 year. Production of more than 500 plants, it's 2 years, and production of cannabis resin for the purpose of trafficking, 1 year. The minimum sentences for the production of Schedule II drugs increases by 50% where any of the aggravating factors relating to health and safety that I've just enumerated, such as, for example, using the real property of a third person to facilitate the grow-op, when those types of aggravating factors are present, the minimum mandatory increases by 50% for Schedule II drugs involving that set of aggravating circumstances. Mr. Speaker, I would like to remind members of this House that this part of Bill C-10 is not just about minimum penalties. The maximum penalty for producing marijuana would be doubled from 7 to 14 years imprisonment. And the amphetamine class of drugs, as well as the date rape drugs, GHB and Ropanol, would be transferred from Schedule III to Schedule I of the Controlled Drugs and Substances Act, thereby allowing the courts to impose higher maximum penalties for offences involving those drugs. And we know from media reports, especially with young persons, that the so-called date rape drugs are becoming a scourge, an epidemic growth among young people, and often with catastrophic and fatal consequences. Lastly, Mr. Speaker, it is important that I also remind members of this House that the proposed legislation will allow a trial judge the discretion of imposing a penalty other than the mandatory minimum on an offender who is referred to a drug treatment court where the offender successfully completes the court-ordered program. And moreover, because we know there are not drug treatment courts in all centres in Canada, so if there is no drug treatment court, the court sentencing the offender can still refer the offender for treatment for his or her drug addiction. Here also, if the offender successfully completes the program, the court would not be required to impose the minimum penalty for the drug offence. And I can state to members of this House, I've had the opportunity and in fact the pleasure to visit the Edmonton Drug Treatment Court on 3 or 4 occasions, and it is absolutely remarkable the work that they do in attempting to get individuals who are involved in criminal activity to feed their drug addiction, to help those individuals break that cycle on, I guess, on a carrot and stick program, where the carrot that they offer is that the person will not be sentenced to prison and in fact could be discharged for the offence if they successfully go to a rehabilitation program and comply with all the terms of their and conditions of their release, including, of course, staying, being abstinent from their addiction, abstinent from all drugs and alcohol, and attending Alcoholics Anonymous or Narcotics Anonymous or whatever programs they're directed to take. And this program, the Drug Treatment Court, I have to tell you, Mr. Speaker, is very, very successful in helping people break the cycle of addiction, crime to feed the addiction, get out, and start all over again. It's a very successful, and I can't enforce enough to members of this House how important that piece of this puzzle is, because it will allow the courts not to impose a minimum mandatory sentence when the individual successfully completes a program as directed by the Drug Treatment Court. In closing, Mr. Speaker, the proposed reforms in Bill C-10 have been carefully studied in both chambers, and may I say, in the committees of both chambers. And I sat on the Justice Committee, and I sat on the Justice Committee in the last Parliament, and this bill, as you know, is comprised of 9 separate but related pieces of legislation, all of which have been studied significantly, not only in this Parliament but in the last Parliament. And this is the type of legislation that certainly Canadians have been demanding. As Canadians are demanding safety and security in their own homes and in their communities, Mr. Speaker. So C-10 has been carefully studied in both chambers. Witnesses appearing before both the House of Commons Standing Committee on Justice and Human Rights and the Senate Standing Committee on Legal and Constitutional Affairs have welcomed these proposals. They have welcomed them because they send drug traffickers and organized crime a clear message. If you commit a serious crime and cause harm to our society, it will mean that you will be spending time in jail. And as a result, because of the provisions that deal with serious drug crimes, as well as the provisions dealing with amendments to the Youth Criminal Justice Act and ending house arrest for property and other serious crimes, changes to our pardon system, all of these separate but combined pieces of legislation have been demanded not only by police and by the chiefs of police, but also by the constituents. And for citizens like that, those that I represent in Northwest Edmonton who have been subject to, sadly, a record number of murders in 2011, 44, and all of the other crime that goes along with organized crime in our city, that this type of legislation is desperately needed. It's been promised and it's being delivered. I encourage all members to vote in favor of C-10 as amended. Thank you, Mr. Speaker.
Questions and comments?
Well, member for Western Arctic.
Well, thank you, Mr. Speaker, and I want to thank my colleague for actually taking the time to go through each one of the statutes in the bill and reminding us again how very horrendous some of these penalties are going to be for people that may or may not fit within his definition of criminality. You know, Mr. Speaker, it's been estimated that up to 300,000 Canadians utilize marijuana for medical purposes in this country. The present marijuana licensing procedures have perhaps 5,000 people properly licensed. So what we have in Canada is a situation where many people are using marijuana for medical purposes but are not legally licensed to do so. So these people who are using it to take care of their health issues are now on the open market. They're perhaps growing plants themselves or doing things to supply themselves with the product that they have identified as useful for their health issues. So now we have a situation where if a person taking care of their own health is found in possession of more than 5 plants, can be given a mandatory minimum sentence for this. The judge will not have any ability to look at the mitigating circumstances. Can my colleague explain to me how this will serve us well in the future?
The honourable member for Edmonton St. Albert.
Well, there are so many fallacies in that question, I don't know where to start. First of all, the medicinal use and permit for marijuana still exists in Health Canada, as the honourable member knows and stated. Health Canada grants permits in the appropriate circumstances to individuals who are suffering from glaucoma or some other pain-related illness that marijuana has been medically proven to ease their discomfort. Nothing changes. And with respect to the suggestion that a person who grows for his own personal use in excess of 5 plants, that person is going to be subject to a minimum mandatory sentence. If the honourable member listened to me, he knows that that's not true. There has to be aggravating factors. It has to be, one of them has to, the most likely one will be for the purposes of trafficking. But if the individual has a permit, he's not operating illegally, and if he's not trafficking, he or she is not operating illegally. So nothing changes with respect to permits issued for legitimate medical use, and in the appropriate circumstances, those individuals will continue to have access, provided that they buy from a grower, I guess, or a distributor that's licensed by the Ministry of Health for so doing.
Questions and comments? Question, commentaire. The Honourable Parliament Secretary to the Minister of Health.
Thank you very much, Mr. Speaker, and I want to thank my colleague from Edmonton, St. Albert, for actually an excellent speech, and I want to thank him for all the good work that he's done on this. I think I'm going to utilize his speech in explaining to my own constituents, because we've heard from the NDP the shameful rhetoric that the opposition parties are putting out on this very important bill. And coming from where I come from, he knows I'm a chiropractor. I had many patients who were addicted to different forms of drugs. And what they told me over and over again, when you get in there, do what you can, because it is a slippery slope. It's people start, and once you're addicted, it's extremely difficult to get off. And that's why we're focusing as a government on stopping people in the first place. I was wondering if he could take a few more minutes to, again, clear up some of the misinformation, because I know in my constituency of Oshawa, I'm having people who are listening to this rhetoric say we're going to be putting kids who are found in their basement with a couple of joints or a couple of plants. Could he please reiterate factually, so we members of the House are able to use his speech to communicate with our own constituents about this important issue. Thank you.
Well, member for Edmonton St. Albert.
Well, and I thank the Parliamentary Secretary, to the Minister of Health, for his good work on the health files and for his interest with respect to addictions. As I indicated, with respect to the production of scheduled drugs such as cannabis and marijuana, which is what I think the member for Arctic was most concerned about, there has to be aggravating factors present. And those aggravating factors, as I indicated, a person used real property that belonged to a third party to commit the offense. The production constituted a potential security, health, or safety hazard to children who were in location where the offense was committed or in the immediate area. The production constituted a potential public safety hazard in a residential area where the person placed or set a trap. So, with respect to trafficking, Mr. Speaker, as you know, often rental properties are converted into grow operations. When those grow operations are either dismantled by law enforcement or simply because of the amount of electricity and the amount of humidity that is required to grow cannabis, as I have read, I don't have any direct experience. That does serious damage to the walls, to the drywall, often to the structural foundation. So that when there's damage to real property, that's the aggravating factor that causes the aggravating sentence provisions to kick in. But just to clarify, possession is not punishable by a minimum mandatory sentence. It's possession for the purposes of trafficking.
Questions and comments? The Honourable Member for Alfred Pellan. Thank you very much, Mr. Speaker, for granting me this time for my question. This is an important issue, and as you know, Mr. Speaker, I represent a riding where we have a number of federal penitentiaries, 3 in fact, one for medium security and one which is going to soon become a minimum security establishment. The prison workers in these prisons and people who work on social integration, and one of the directors told me about this 2 weeks ago. He said, what counts for me is to ensure, because these people will eventually be released, so he said what counts for me is that all of this happens in a safe fashion. So these people could come out of prison and be my neighbors. So he wanted to use a social approach and ensure that these people were properly reintegrated into the community. So what I would like to know from my colleague is very simple. In 2010, the crime seriousness index reached its lowest point since the 1980s. So I would like to know why the government is claiming that this bill is now more necessary than ever, whereas we have seen that crime rates are declining.
Honourable Member for Edmonton St. Albert.
Well, thank you, Mr. Speaker, and I thank the Honourable Member for her good question. 2 aspects to it. As I indicated in my comments, this bill, the part of C-10 that deals with serious drugs, is part of a national anti-drug strategy that has 3 distinct prongs: preventing illicit drug use, treating those with illicit drug dependencies, and combating the production and distribution of illicit drugs. So I concur with her that individuals who have addictions and who are incarcerated because of those addictions have to have access to rehabilitative programs. And the Public Safety Committee in the last Parliament, as she might know, wrote a comprehensive report on drug dependency and rehabilitation programs that are available in the federal penitentiary system. But the second part of her question is actually more challenging, and that's this whole notion that crime is somehow on the decline. And I guess I have to acknowledge or concede that officially reported crime statistics, as reported by Statistics Canada, based on how they measure crime, has in fact shows decreases. But if you look at Stats Canada also does a crime survey or a victimization survey where they survey individuals, survey Canadians on whether or not they've been victims, and victimization is way up. And in any given year, over 25% of Canadians state that they've been a victim of crime. Happily, most of that is property crime. It's not serious. But nonetheless, victimization surveys show that crime is up. So with respect to this notion that crime is somehow diminishing, that's only officially reported crime statistics, and the reason for that is two. Number one, the police have changed how they measure crime, i.e. if you break into 3 houses on one night, that used to be counted as 3 crimes, now it's counted as 1. But the bigger problem is Canadians are so fed up with the justice system that they're not reporting crime. So officially reported crime might be down, but crime is not down.
Resuming debate, the honourable member for Surrey North.